Hanni's visa issues could shake up the future of NewJeans, and the internet is buzzing about the latest Vogue shoot. From legal risk to public perception, let's unpack all the issues that the group are facing and what it all means. Hi guys, Han here. If you've hung out with me before, then welcome back. And if it's your first time hanging out with me, hi, I'm Han. I'm a K-pop fan of almost 20 years, and I've also lived and worked here in South Korea as a marketing expert in the K-pop industry. And having studied, lived and worked in Korea for collectively over 6 years now, I do fancy myself to be a little bit of a visa expert. In fact, it's actually a running joke amongst me and my friends that I know more about visa stuff than the actual immigration officers, because I think it is quite literally the most important thing to know about if you are a long-term resident in a foreign country. And I'm sure you guys understand that that is going to be relevant today, because we are going to be talking about Hanni's potential visa issues alongside the legality behind NewJeans' recent Vogue photo shoot. And as always, these are going to have bigger implications in the ongoing HYBE versus NewJeans versus ADOR versus NewJeans case, aka ADOR Gay. An ongoing series you can check out in the little iCard above. So without further ado, let's get into it. Okay, so we're going to be starting off with what I personally find to be the most interesting part, which is Hanni's visa situation. I'm going to be going over some basic information first, talking about what Hanni's options would be moving forward, and then answering questions that you guys actually left on my community page. Thank you for those who did leave questions. And if you didn't know I had a community page, well, every YouTube channel does. It's free, it's public. Check it out sometimes. There might be an opportunity for you guys to suggest ideas or something. So yeah, anyway, as I'm sure you guys all know by now, Hanni is non-Korean, which means she would have been working in Korea on a visa. She does have Vietnamese and Australian nationality, so she's got passports for both, but that means that she would have to have a working visa to work in Korea as a K-pop artist. As far as we're aware, she has been working on an E6 visa, which is an entertainment cultural activities visa. Now, to make some sense of that, there's two things you guys need to understand about visas in Korea. Firstly is the letter classification, which usually corresponds to the type of visa it is. So the three that we're going to be talking about are D visas, which are education or pre-employment visas, like internships and that kind of thing, job seekers also. E visas, which are employment visas, like working in specific jobs. Different jobs will have different numbers. And then F visas, which are residency visas, which is actually what I have, so we can talk a bit more about that and relate it to Hanni's situation in the future. The second thing you need to know is the numbers, which each number does not have a meaning, but when you combine it with a letter, it has a different meaning. For example, an E2 visa is an English teacher or language instructor visa, whereas an E7 is a specialized worker visa, something like marketing or business or science. So different E visas will have different job scopes. An E6 visa, the visa that Hanni has, is called a culture and entertainment work visa. It's usually used by models, creators who are signed to MCNs, and of course foreign K-pop idols. There are three important things to note about this visa. Firstly, you have to have an employment contract at the time of your application, and this will be the company who is essentially what we call sponsoring your visa. People understand that to mean like paying for your visa, which is actually usually not the case. It's very rare that they do, but I'm sure for a K-pop company, they can afford to pay like the $60 for your visa, so maybe they are. The second thing is that an E6 visa is usually granted on a single year basis, even if your contract is longer than a year, and then you have to renew it each year. It's very, very uncommon for anybody to be granted an E6 visa for more than a year in any case. And lastly, you are not allowed to work at anything that is not directly under your sponsor for your E6 visa. So in the case of Hanni, she's not allowed to work in anything that is not directly organized by or within the scope of working for ADOR. So very important, right? I'm sure you guys know, ADOR themselves have also said that they are actively preparing the documents for Hanni's next extension, and I couldn't find information on when the extension was, but my memories tells me that it would be next year April, and I can actually tell you exactly what this documentation is because it's standardized amongst all E6 visas. Basically, they would have to give a rough outline of what activities she would be doing within the time frame of this visa, which means that ADOR would actually have to have a monthly basis, like outline of what NewJeans activities Hanni would be participating over the coming year, which goes hand in hand with them saying like, oh, we prepared a tour and an album and all these other things for you. I'm sure they have, because they literally have to have some sort of They don't have to have evidence per se, but they have to have just a written document of this is what we're preparing that they were going to submit to immigration. They would also submit things like their business license and registration and just other things to prove that they're a real business. But again, because this is the same job and it's just an extension, it's actually pretty easy because they're just submitting the same documents they've already submitted. The other things that would need to be submitted would be Hanni's actual application in and of itself for the visa, which Hanni herself would need to sign, which we will come back to in the future. The main question that we're going to be exploring today is what happens to Hanni's visa if she leaves ADOR, and does she even have a visa right now? And for the sake of answering this question, I think we have to look at it through the lens of where Hanni stands herself, because obviously there's still the whole debate of whether the contract is valid or not. Personally, I'm team it's valid. Just like you're innocent until proven guilty, they can't say that ADOR has violated the contract without actually proving that they violated the contract in court. So as far as I'm concerned, the contract is valid. But for the sake of this conversation, to understand Hanni's options, we're going to talk first about if the contract was actually cancelled or terminated or whatever you want to say, which is obviously what Hanni herself believes. Now, the issue that presents for Hanni is that if she said that as of November 29th, the day after their sudden press conference, they have officially terminated, or their contract has been terminated by ADOR and NewJeans are now free, this would mean that her E6 visa is no longer valid, and she would actually have 2 weeks, i.e. until December 13th, to file for a new visa, whatever that visa might be, or to leave the country. She obviously left to go to Japan, but she returned to Korea, and we will get into the technicality of that, but she would have to have a visa now to be doing the activities she's doing, like the Vogue Shoot, the performances, and radio appearances. So even though she left the country temporarily, she still needs to have a visa right now to do those work activities, because you cannot work without a work visa. I think one of the other important nuancial things to take into note is that this is her essentially cancelling her visa early, whether you want to see it as the company is cancelling the visa for her or she's voluntarily cancelling the visa herself. Ultimately, this is a different situation from if she had actually finished her visa term and the visa just expired. This is her actively cancelling it early, which is something I have personal experience with. I cancelled my student visa when I was studying here in university because I became sick and I had to go home early. And the way that this process basically happened was that I informed my school that I wasn't going to be continuing to the next semester, and they informed the immigration office that they were no longer sponsoring my visa because I was no longer their student. And I literally got a summons in the mail within 2 days. The immigration office was like, get your ass here, and they sat me down and when are you leaving the country? And I was like, I have a flight booked, here is the reservation. However, I would be going to Japan first, coming back to Korea, wrapping things up here within a week, and then going. That total amount of time from when I actually cancelled my enrollment at the school to when I left the country, or other way around, was about 1 month. The immigration office were fine for me to do that because I had a proven plan of when I was going to leave the country. Also, because I went to Japan and then came back to Korea, technically for that last week I would have been a tourist, but they actually just let me keep my visa until that final day when I left the country. So there are exceptions and ways that the immigration office can accommodate you, but they have to be within reason, and you still have to show your intent to leave now that your visa is no longer valid. So what would Hanni's options be? And as Richard6025 so aptly put it, can't you just apply for a different type of visa? Yes and no. We're going to go through the different visa options she has and talk about what difficulties she might face in getting that visa, or how this could help her out in this situation. So the first option she would have is just getting a new E6 visa, signing with a different company and having them sponsor her. That is not possible. And the reason that's not possible is that to move between sponsors, even on the same visa, it is a new visa application. It's not an extension, which means you have to go through the same basic beginning process of proving all the things, submitting all the plans and all this kind of stuff, the company proof and all those things. But the more important thing is that you need a letter of release. This is something I have personal experience with. I have had 2 letter of releases in my time in Korea. The first one was from my teaching job when I moved to my first marketing job, and then I got a second one when I moved from my first marketing job to my second marketing job, and by the time I left that job I had a residency visa. So if you are still on a working visa, you need a letter of release from your previous employer before you could even apply for a visa with a new employer. And this is very important because this stressed me out. this really stressed me out, and we'll get to that. As ADOR is obviously asserting that Hanni is still actively in contract with them, there is no way that they are going to provide her with a letter of release, which means she cannot apply for an E6. Even if she did find another company who's willing to sponsor her, which ADOR could very easily try and sue them and be like, you're illegally employing our employee, which would also result in, I haven't checked this since 2021, but as of 2021, it was a 30 million won fine if you were found to be illegally employing somebody. So I don't know if that's higher now or whatever the case might be, but at least a few years ago, that's what it was. You might say that's a small price to pay for Hanni, but if you were found guilty, you wouldn't be able to keep her anyway. The other flip side to this as well is that if she were signed to another company, it would make the work she's doing for ADOR illegal because she's no longer their employee. So even though NewJeans are saying like, oh, we're going to fulfill our contractual obligations or our pre-existing schedules or whatever, if she had an E6 visa under a different company, that would be illegal because she's not employed at ADOR, so she can't work for ADOR. So either which way, it just doesn't make sense for her. And as far as we know, she's not signed to any new company anyway. So I highly doubt this is the route she would have taken, even if she wanted to. Hanni's next option would be what's called a D10 job seeking visa. And a D10 is something that lets you work the same kind of jobs as an E1 to E7 visa would, but it's usually given in special cases where, let's say your 2 contract periods just have a little bit too much of a gap. It can even be actually up to 6 months. But let's say you've got something lined up, but you just aren't starting soon enough, or maybe you need a couple more documents from your home country to fulfill all the requirements for the visa application, whatever it might be. A D10 is a nice like intermediate visa that still allows you to work to some extent and earn some money, but cannot replace an actual work visa long term. But this also comes with some cruxes that I believe are the reason that it's not going to be the route that she's going down. Firstly, you can only work as an intern, or you can work as a probational period officer. So let's say you have like a 3-month probation at the start of your contract. You can work that period on a D10, but you have to have applied for your work visa, your E-visa, by the time you start working as a full-time employee. As far as I know, there aren't really intern positions for idols, so it'd be hard for Hanni to claim that. And also, she would still actually need a letter of release to apply for a D10. So, that's not gonna work either. The third option, and honestly one that I feel like a lot of people have kind of looked over, is actually a tourist visa. As I mentioned, I left Korea after my student visa expired and went to Japan and then came back, which is essentially called border hopping. I didn't do it for that intention, but it just so happened to be that was my schedule. Anyway, the point that I'm making is that once you've left the country and you've cancelled your visa, when you re-enter the country, you can re-enter as a tourist. Now, I'm not sure the exact legal like immigration agreements between Vietnam or Australia, but I imagine for both of them, you would at least have the typical 90 days free travel within Korea. But of course, Hanni is not a tourist. She's actively working, which would also be illegal on a tourism visa. You could say that she could get around this by having all contracts signed by the other members and all the money wired to the other members, because in that case, there's no like on paper trail to prove that you did some work. You could say like, oh, I'm here as moral support, or I'm here for the experience. I mean, of course, we all know that's bullshit, but like legally, there's nothing to prove that she did work, if that makes sense. It just so happens that one of the NewJeans girls withdrew amount of money and then she would have deposited that into her own bank account. But I mean, for all intents and purposes, this is an option she could use. It just wouldn't be a very smart one. But yeah, I say all of this to say that these 3 options, the E6, the D10 and the tourist visa, are all generally pretty terrible, but I wanted to mention them because they are options still in a way, or things that people have had questions about. So what do I think she's actually going to be doing? Well, I think she's going to be going down the investors route, and there's actually 2 really good visas that she can get, which are both F series visas. So F series is, as I mentioned, a residency visa, and it's something I have now, so I can kind of tell you a bit more of like what the differences are. Beyond obviously being an idol and having her career here, there's actually a lot of reasons why Hanni, or anybody really, would want an F series visa over an E series. And that's simply freedom. Like, as we've already discussed, on an E visa, you're pretty much tied to your job, and your ability to like move on and do anything else kind of is reliant on you ending on good terms with them. They can refuse to give you a letter of release if they think that you weren't a good worker, or they feel like you don't deserve another visa, or they just want to mess with you, honestly. And I know people who've been through that case of like fighting their hagwon or wherever it is they're working to get their letter of release, whereas on an F visa you have complete and utter freedom. And in this case, the most important thing to Hanni is that you have employment freedom. You don't have to meet certain requirements to get certain visas to get a job. You don't even have to tell the immigration office what job you're doing. You just need to tell them where you live. So I personally am on an F27, which is a points-based residency, short-term residency visa. You can get earned points through things like cultural knowledge, language skills, your education background, and how much you earn. And for me, it's been quite honestly life-changing to my experience. I quit my previous job, which I actually started off on an E7 visa when I started that job, and I changed to my F2 during that period because it was horrible. It was hell on earth. I was miserable. I was crying every day. Anyway, I could leave freely because I wasn't tied to my job. I actually took 3 months off and just enjoyed my unemployed best adult life. It was the best 3 months of my life, I tell you. And then I started working freelance as a translator and a marketer, and then I eventually started working my hagwon, and now I do that. I kind of have my own little small side business where I do group orders, and I have this YouTube channel which is making money for the first time. Yes, sir. And I can do all those things without having to tell immigration office anything, and it's just such a nice feeling. Anyway, back to Hanni though. The first visa that Hanni could possibly get is an F212, which is a general investment visa. This is a special investment visa run by the Korean Development Bank, and to qualify for this visa, all Hanni would need to do is invest 500 million won into the Korean Development Bank and leave that investment in Korea for 5 years. Doesn't have to touch it, doesn't have to do anything with it. They will invest the money, and after those 5 years they will give it back to her, and actually at the end of those 5 years she can upgrade to an F5 visa, which is a permanent residency visa. So once she upgraded to an F5, she would never have to invest again, she would never have to apply for a visa again. You get your green card essentially, and you go to immigration every 10 years just to update your photo, and that's it. She would be free to do whatever she wants in Korea for as long as she lived. And we already know last year that each member of NewJeans got paid like 5 point something billion won, let's say 5.1 billion won. So 500 million won is not a big deal for her to pay, and mind you, that's what they got paid last year. Who even knows what they got paid this year as well. I'm sure they have more than enough money if she wanted to go down that route. The other option she has is going straight to the F5. She could go to an F525, which is a special investment visa. But this is essentially the same thing, but it comes with a slightly higher price tag. She would have to invest 1.5 billion won, which is a substantial chunk of change. But again, based on the fact that she earned over 5 billion last year, and she's probably earned something within the similar range, maybe a little less because of all the drama, but I could still see a good like 3 billion maybe. It shouldn't be an unrealistic amount for her to invest. It is worth noting that the highest income tax bracket in Korea is 45%, and yes, foreigners do also have to pay the same income tax as Koreans. So she would have paid a lot of that 5 bill to the Korean government, but I still think if she's wise with her money, there's a good chance she has enough to be able to invest that money for the 5 years necessary, and then after those 5 years her visa is solidified and she can stay without continuing to invest. So the only crux to both of these visas that could get in her way is that technically the money you're investing should have been earned outside of Korea. Now we all know that she earned that money as a K-pop idol in Korea. She was paid via ADOR to probably a Korean bank account, or at least technically the wires would be coming through Korea, right? Actually, it would have to be a Korean bank account because you'd need to pay the taxes here. But the easy way to get around that is simply just to send the money to Vietnam or to Australia and then send it back. They don't need to know how you earned it in Vietnam or Australia. As long as the money was there in your Vietnamese or Australian bank account and now it's here in your Korean bank account, you can invest it. So that's the easy way to go around this. And I actually have a friend who, or an ex-colleague should I say, who has done this exact thing. He saved a bunch of money in Korea, sent it back to the US, and then sent it back to Korea, and he used that to invest to get his investment visa. So it's not something she can't do, but of course when you're talking about moving quite literally like millions of dollars worth of money, you are going to have to make a few trips to the Korean bank, the Vietnamese bank, the Australian bank, whatever bank she's using, and I imagine that process could be quite time consuming. I don't know how many schedules NewJeans have after the kind of year-end period. Maybe January would be a good time for her to get all that done. But moving on the assumption that her visa is expiring in April, she has more than enough time. And generally, when you're paying a lot of money, things move pretty fast in Korea. So I don't think this would be a long process for her to get that visa if she had the money on hand and she was ready to pay. So ultimately, it's not impossible for her to get another visa, but the few options she has are very expensive and will be a little bit tedious and time consuming. One thing that everybody who's talked about this so far has kind of missed is that regardless of whether Hanni and NewJeans say that their contract is terminated or not, her E6 visa is actually still valid. And the reason it's still valid is the example I gave with my school. The school had to inform the immigration office that they were no longer sponsoring my visa once I had unenrolled. In the same way, ADOR needs to be the one to inform the immigration office that Hanni is no longer their employee for her visa to be invalid. So until ADOR decides to make that move, Hanni is still very much under the ADOR E6 visa, because as far as ADOR is concerned, she is still their employee. She is still liable for breaking her visa rules by doing independent work and other things like this, which would be quite interesting. Even if the court does rule that her contract was terminated, I doubt that ruling would work retroactively. I feel like it would be from the ruling that her visa is expired, if it's not already expired before then, which it would be, because obviously the lawsuit's going to take way longer than April. So regardless, until April she's safe is the point that I'm making, but she could still be legally liable for breaking her visa, which could harm her chances of getting a new visa. If you break immigration law, you're usually fined. It's not really a big fine, it's like $100 or something like that, depending on how serious the incursion is, and she may be like taxed something extra on the earnings she made illegally, but honestly, as long as she pays all those fines, it's very unlikely that's going to significantly hinder her in getting any of the investment visas that we spoke about, especially with the amount of money she's investing. Like, money talks no matter where you are in the world, unfortunately. But yes, also, this is not something that somebody asked, but I think this is worth mentioning. ADOR cannot file the visa application on Hanni's behalf. That 100% cannot happen. I've already spoken about the documents they are preparing are things she needs as part of her visa application, but ultimately her visa application is her own private matter. Companies, what it all means, can employ lawyers to help you. They can send representatives with you to help talk, especially when there's a language barrier as well. It's been done before, and I've seen it happen in many cases. Actually, my very first work visa, our school representative, the Minister of Education representative for our area, came with us to the immigration office to file all of our applications. But Hanni herself would need to be there, and she would need to sign because it is her visa. So there is no way where ADOR could file the visa for her without her actively being there and being part of the process. Which, of course, if she were to do that, would be her admitting that she is in fact an ADOR employee, and she would actually not only be admitting that she's an ADOR employee up until this point, but she would also be agreeing to be an ADOR employee for the next year of this visa. So it would go completely against the case. I don't see a world in which Hanni goes with ADOR to file for this extension. So with all that being said, I think it's time to get into the questions that you guys asked before we move on to the Vogue situation. But I just want to take this moment to remind you that if you've enjoyed this video thus far, then please leave a like and consider subscribing if you enjoy this kind of content, especially if this is not the first time you've watched one of my videos. It would mean the world to me, and I really appreciate it. I'm trying to hit that 5K, guys, let's go! Anyway, is it true that an employer, which is ADOR, has to release her for her to find a new employer visa? Yes, as we've discussed already, ADOR would have to give her a letter of release for her to even apply for a visa with a new company. Or is the investment visa valid as a loophole for her to work around it by just investing in South Korea while continuing to be an entertainer. Yes, as I also said, if she was to do an investment visa, she would be on a residency visa, an F-series visa, which means she would have freedom of economic activity. She could start her own business, she could be an idol, she could open a brand, she could do whatever the hell she wanted. As long as she's paying taxes, they don't care. If she were able to apply for a new visa, how likely is it that that application would be rejected? I mean, NewJeans and Minhyejin are creating problems right now, especially in the entertainment industry. If I were an immigration worker, I wouldn't want those kind of people in my country. As archaic and conservative as Korea is at times, immigration is pretty cut and dry. You either qualify for a visa or you don't. And unless you've done something that you've legally been punished for, like you've had to pay a fine or you've done jail time, generally your good or bad conduct will not affect your visa application. The immigration officer doesn't have to like you, but they have to do their job. They can absolutely make your day miserable though. Frankly speaking, the only reason her application could be rejected or stopped rather is if the immigration officer decides that one of her documents is not valid or some sort of information is missing or she needs to provide something additional, which they very much well can do, mind you. For my first E7, my first office worker visa for my marketing position, I had to apply 8 times. Or actually no, technically I went to the immigration office 8 times. It was on the 8th time that they actually accepted my application, like allowed me to submit the application. They check all the documents when you visit the office and they won't even let you start the application until they've approved all the documents there. And it is extremely rare for there to be a problem after they've accepted the document. So you can see as once they've accepted it, you're good, but it can be a pain to get to that point. And let me tell you, there were many days that I cried in that immigration office because, oh my goodness, 8 visits and 3 months. And I'd already quit my previous job because you have to quit to get your letter of release. Oh my gosh, I was stressed out. But I digress. Also, for what it's worth, even though, yes, maybe that individual immigration officer may not like NewJeans or Hanni and all the aggro they've given the South Korean public, there is still a small section of Korean people who do like and support NewJeans, so I doubt that would be a basis for them to grant or deny her a visa. Next question. How big of an issue is this for her? Will ADOR still file the documentation even though she denies being part of the company? And if so, will they accept it, the visa office, since this issue is so public? As I've already discussed, ADOR cannot file on Hanni's behalf in any circumstance. As it's Hanni's visa, she has to be a part of that application process. Mind you, one of the most important documents you need for a visa application or extension is an employment contract, which Hanni is actively saying is not valid. Even if we say the old one is like terminated, she would have to sign a new employment contract with ADOR for them to sponsor her visa, which she wouldn't do. So absolutely under no circumstance can ADOR apply for her. I'm curious to know, if Hanni were able to apply for a visa independently of them, could ADOR challenge it, thus essentially boxing her into acknowledging the contract with him? Now, I thought this was a great question because this is something I had not considered before, but unfortunately, no. And I can say this from my own experience. When you change your own visa status, especially if you're changing from a work visa to a residency visa, you don't have to inform the company. And I know this because this was my case. I was actively trying to leave my company when I changed my E-visa to my F visa. And the only time that I actually informed them of that change was when they were doing my taxes, because your company does your taxes at the end of every year. So in Hanni's case, if she were to cancel her E6 visa herself, they would probably be notified that, hey, your employee's come to cancel her E6 visa. But you don't even need to cancel to apply for a new visa. She can actually just put in the application and then that automatically gets processed to the F visa, and she never has to tell them anything. I imagine she would at some point tell them for the tax issues that I mentioned, but at that point there's not really anything ADOR can do. They can't challenge her and be like, she doesn't deserve to be a resident because we want her to be our employee. Yeah, so that would be about it. But a very good idea and great question. Anyway, I read somewhere that she already had a plan B before the issue became a thing, and maybe they've discussed this with the Australian embassy and they somehow handled the situation for her. So what do you think of this theory? Put simply, nah fam. An embassy does not have any authority over immigration law in another country. technically the land of your embassy is considered part of that country. So like if she's inside the Australian embassy, she's inside Australia, even though it's in Korea. But besides that, the minute she steps back out into Korean society, she has to have a valid visa. She might have already started an application before this came to light. She wouldn't need to go to the embassy to do that. Like, she would just need to go to an immigration office. Maybe she could have got like a consultation at the embassy for some advice. I don't know. But again, you could do that at the immigration office. I think it's very highly unlikely that her embassy is at all involved with this process, because it's not a diplomatic issue. It's just a girl and her visa. Like, on the face of it, yeah, I know she's a celebrity and money talks, but on the face of it, she's just a girl on her visa, so I don't think the embassy would do anything. I don't know if I'm late to ask this question, but I'm curious on if it will end up good with all the stuff happening. I heard that to get the long-term visa is very hard. I don't know if her position will make it easier or more difficult. I did hear someone in the group didn't have that visa yet. I don't remember who, but I do remember some people saying someone also didn't have their visa. I don't know how it works in Korea, but does the court case and evidence affect the visa, idol celebrities, or any other or only regular civilians? So as I've kind of already implied, there's a few things here. There's no difference between regular civilians and idols. A visa law is the same for everybody everywhere. There are even cases of where K-pop idols have not been able to perform in other countries because their visas were not ready on time. You have to have a visa to work in another country regardless of what the country is, unless it's something like the EU where you have freedom of movement agreements and things like that. So in this case, no, her being a celebrity does not affect her visa application. Now, in terms of the case affecting her visa application, as I said, unless ADOR actually report her contract as being cancelled, her E6 visa is, as of yet, still valid until the expiration date comes. And she still potentially has a few more months of that. She has plenty of time to sort out a new visa and get that application rolling before her current visa expires. One thing to note is that she only has to file the application when her current visa expires, and she's kind of like in this temporary like extension. So for example, let's say she has 1 week left on her E6 visa and she files for her F visa. That E6 visa is extended until that F visa is either granted or denied. So the application's in process and she'll be given like a temporary piece of paper which she can use to do like her banking, her phone, all these other things that show, yes, I have a ID number, a social security number, but my visa status is being changed, and because of that I don't have the physical ID card, because you have an ID card for every visa you have. So if you change a visa, you have to submit the card and then they'll give you a new one with the new visa. So when I changed from an E2 to an E7, I had to submit it. When I changed from E7 to an F2, I had to submit it. If I change from F2 to something else, I'll have to submit it again. So besides that, generally I think she'll be good. As for the other members, I think you might be talking about Danielle possibly, who is, as far as I know, she's a dual citizen. She's Australian and Korean. If she isn't a dual citizen and she only has Australian citizenship, then for her the easiest visa to get would actually be an F4, which is an overseas Korean visa for people of Korean heritage born and raised outside of Korea. And she could apply for that directly. She doesn't need to go through like the E6 and all these other things. And yeah, it's an F visa, so she'd be able to do everything a Korean could do basically, except vote. Anyway, next question is, I'm curious as to who even brought up this issue in the first place. Whoever did this thinks about NewJeans way too much. Was this their way of baking ADOR into taking care of her visa, or did they actually think this through already, and are they working on it themselves? Even if it's all speculation, I'd like to hear your theory. Honestly, I can say this as a foreigner who's lived in Korea for a long time. Visa is kind of like this like dark cloud that is looming over your existence every day of your life here. Like literally everything you do, you're like, can I do that on my visa? Like it is, I cannot stress, even having an F visa now, which gives me so much more freedom and so much more ability to do what I want, I am still constantly worried about keeping my F visa because it's not permanent yet. So honestly, I could very much see this being like something that other foreigners who are like living in Korea and watching the situation were like, I wonder what's happening with her visa, and then maybe a reporter picked up on that or something. I know there were some people who were saying that because NewJeans donated or like sponsored some free food and drinks and stuff for people protesting the impeachment of the president, who is largely supported by young men in their 20s and 30s, i.e. incels, that maybe some of these guys then went and reported her to immigration because they wanted to like spite her for being a foreigner and getting involved in their domestic affairs and all this. Tin hats, okay? Tin foil hats. It's not that deep. I honestly feel like this is just a very smart journalist who was like, you're a foreigner, you, especially with her having recently gone to the National Assembly and made like this whole spectacle of herself as a foreigner as well. Like, a lot of people were like, even if she had something to say, why did they send her and not one of the other girls when she's not even Korean? Like, that was genuinely a response that people had to her being there. So I could see a reporter just being like, oh, speaking of her being a foreigner, what's going on with the visa situation? You would also be surprised how little Koreans actually know about visas. This is a very fun topic that we talk about on my Hagwon all the time in free talk classes, because people always ask me like, oh, how long are you planning to be here? What kind of visa are you on? Blah, 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 blah. And then I tell them all the horrors of like why I'm on the visa I am and why I don't really have many other options besides becoming a Korean citizen, which is a video for another day. That's actually something we're working on, but like I said, a video for another day. But yeah, visa law in Korea sucks. the long and short of it. And unfortunately, Koreans are not very aware of it. The final question is, can you also talk about the Vogue shoot that they did without crediting the group name and ADOR, even though they used ADOR Human Resources? Also, the new advertiser Omega watch, not crediting ADOR and the group name. How is that legal? Great question. So, for those of you who missed it, I don't think there's any of you here, but just in case, NewJeans recently featured on a 12 variation cover shoot for Vogue magazine Korea, which drew a lot of attention for a number of reasons. First things first is the excessive number of covers that they did. Even big groups like BTS usually do one per member and then a group shot and that's it. But 12 seemed a lot. Anyway, I don't know, there's only 5 people there. But more importantly is the fact that they did not use the name NewJeans. They actually did everything under their individual names, Hanni, Danielle, blah, 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 blah. And on top of that, they had a 52 spread in the actual magazine, which actually I don't think is that significant. January is pretty much a slow month for the fashion industry. It's in between fall winter fashion week and spring summer fashion week, so there's just nothing happening. I just think it's just a throwaway. But anyway, I digress. And most importantly is the fact that ADOR was not credited in the magazine covers, but guess who was? Our favourite person. You know her name, Min Hee-jin. Yeah, she was credited as the creative director and producer of the photo shoot. So, a lot of interesting things going on here, and we're just going to get into each of them. So, the first thing I would like to say actually is just I want to correct my previous video, because I know I said that allegedly the Vogue photo shoot had been cancelled, and obviously I was wrong. I can put my hands up and admit that. From my new understanding, it seems that Vogue had offered the photo shoot to Min Hee-jin when she was still CEO, or at least working in ADOR, and she had accepted that because they had also invited her to be the creative director of the shoot. Following her removal and the whole contract termination thing, Vogue had pushed forward with their plans to carry out the photo shoot, but they had kind of excluded ADOR from the process. So technically this is a schedule they would have already had on ADOR's books. So technically it's an ADOR schedule. Like, you know, they said they were still carrying out all the schedules. It's an ADOR schedule, but the schedule was made on the premise that Min Hee-jin, as a freelancer, as an independent person, would be the creative director, which obviously they still moved forward with. And I think that's why they didn't cancel the photo shoot completely. But at the same time, because all the creative stuff is happening with Min Hee-jin, it was a bit easy for Vogue to cut ADOR out of the process. Now, there's a few main points that we need to get into to answer this question. Firstly, is this a breach of their contract? And I would say that's hard to say. Technically, as we've discussed, this is an ADOR schedule, and they've already said that they would carry out their pre-existing obligations. And in previous videos, we've already talked about how, although it's hypocritical or contradictory for them to say that they're free from ADOR to still be doing ADOR schedules, it's also a way for them to save themselves legally, because if ADOR does end up being proven right in court and they don't do these schedules, that can be used as misconduct. So in NewJeans, from NewJeans' side, they kind of have to do this, but I think the way they've gone about it is what makes it a bit more interesting and controversial. The second thing is the girls making it a point not to use the name NewJeans, which is not the first time we've seen this, and I think they're doing this to cover their asses legally. On the flip side, in the case that they are proven to be free of ADOR, they can claim this as their own independent activity later because the name NewJeans is not attached to it. Whereas if they do it under NewJeans, that belongs to ADOR's IP, so they would have to leave behind all the earnings and whatever from this if they were to have terminated the contract. I also think, this is just my personal speculation, I think if the contract termination was found to be valid and they did this under their own names, they could potentially sue ADOR for the profits that ADOR would have taken from the schedule. I don't know, because like I said, it's technically an ADOR schedule, so I don't know how that would work. But then if the contract is cancelled, technically all the ADOR contracts are cancelled. No? I don't know. Someone with more legal knowledge than me, you dissect that for us. But I do think it's a legal play for them to keep their options over. If they end up still being NewJeans under ADOR later, no harm, no foul. If they end up getting out of it, there's potential for them to keep this as something they did themselves, not something they did under ADOR, even though that's a very grey and confusing area. And obviously there's the public perception of this. It's showing them being successful, being on quite literally Vogue magazine, the Vogue magazine, as themselves, not as NewJeans, which shows that, look, we're thriving, we're living our best lives since we've left ADOR, we've not lost anything, we're still here, we're still queer. No, that's just me. Anyway, also, there's the big thing of them working with Minhyejin is not actually inherently against their contract. In our previous video, we did talk about the dispatch leak where they showed that Minhyejin had been encouraging NewJeans to leave ADOR even when she herself was still actively working in ADOR, which could be seen as artist tampering, which is very illegal. But in this case, Minhyejin is only here as like an independent freelance creative director, and whether the girls are there as NewJeans or there as themselves, they're there for a photo shoot. Yes, maybe in the initial contract negotiation, they could have talked about like, oh, we want this director, or we want this photographer, or something like that. But again, considering this was a pre-existing schedule, I think it could very well be that ADOR overlooked the fact that Minhyejin was supposed to be part of this, or maybe they even thought she wouldn't turn up because she's got her own legal issues to be worrying about. But whatever the case, her working with the girls in this capacity is not infringing on their contract in any way because Minhyejin no longer has any obligation to ADOR. I mean, they wouldn't like it, but not much they can do. I think the actual big thing here is the not crediting ADOR even though they're using their resources. And I think this is, again, a very difficult thing to assess because we don't actually know to what extent ADOR and their resources were involved in this. As we've said, this was it should be an ADOR contract. It should be an ADOR schedule, but we know that the girls have allegedly not been going to their dorm, allegedly only been going to the company when they see fit or when they want something there. We don't even know if the managers would have been present. We don't know who would have driven them there, if it was their own drivers or if it was the ADOR drivers. Like, we don't know who did their hair and makeup. It could be that they did this with very little input from ADOR and a lot of input from Minhyejin, which I think is very feasible. And we know that ADOR is not credited on the cover images. I don't know if the actual physical magazine is out, but if it is, I haven't seen it. There is still a good chance ADOR could be credited in that. But again, I'm not sure. So it's kind of hard to say. I will say that if ADOR is not credited anywhere in the magazine, that would be a pretty ballsy move for Vogue to make. And I do think that would open them up for litigation from ADOR to say, you can't do this, you're working with our artists who are still under us and blah, 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 blah. But again, Vogue is also like a huge multinational company. They probably could afford whatever the price they would have to pay to ADOR is. And honestly, this is not a wild thing to say. With it in Korea, there are many times people would do things that they know are illegal because they can afford to pay it. For example, I'm sure you guys have all seen like the idol buses, like the huge long coaches that drive around the cities for idols' birthdays. That kind of rap advertisement is illegal in Korea. But you know what fans do when they fundraise for that? They pay the cost of the rapping and they pay the cost of the fine together, and it's just over and done with, and that's why it's so common. So it's not a weird concept for people to do things they know are illegal if the punishment is a fine, because they know they can afford it. So I do feel like it's not worth it on Vogue's side. I don't think the sales they're going to get from NewJeans are going to be significant enough to make it worth it aggro, but I don't know. I also do think that it could be that ADOR is waiting for the legal precedent of their main lawsuit to go through first, and then they might just sue everybody who crossed them at the end, because once that legal precedent of NewJeans still being their employee is set, it makes all the other lawsuits so much easier, rather than going into these lawsuits now and then being like, well, you can't even prove that they're really your employees, if you know what I mean. In terms of the Omega Watch collaboration, this is actually believed to be the deal that the employee they discovered was trying to set up independent activities for NewJeans was working. So I don't know if you guys remember, there was an employee who they were investigating, and they seized the laptops, but the laptops had been wiped and all this and that. But it's believed that this was the deal that that employee had actually set up for NewJeans, independent of ADOR. So in this case, there's absolutely going to be a lawsuit at some point where ADOR will come out and be like, we didn't agree to this, we didn't have this on our books, we didn't have this on our schedule, you owe us money, this is not But as I said, I think it's ultimately not that ADOR can't do anything, but they aren't doing anything yet. I think if they were to go into all these lawsuits now, it would be spreading their resources thin, and it would be a waste of, honestly, a waste of energy, because ultimately they can't win any of these other lawsuits until they've proved that their contract with NewJeans is still valid. So I feel like it just makes sense for them to do that first, set that legal precedent, and then go for all the people who are like, hey, you didn't run us our check, hey, you didn't sign our contract, hey, you worked with our artists without our permission, because once they've got that, it just makes the whole process easier. Hybe's side in general, and bearing in mind ADOR and Hybe are using the same lawyers, have been very meticulous through this whole process, and unfortunately that level of detail ends up with things being quite slow. So I don't think lawsuits will come out of either the Vogue or the, I don't even know if there's a lawsuit there in the Vogue situation, but at least with the Omega Watch, I don't see anything happening anytime soon. I also do think that it's very likely there won't be any issue between ADOR and Vogue, because ADOR did actually end up sharing the images and the official tweet and other things from Vogue on their official networks. So I think they probably did some talking behind the scenes. Maybe they got paid their share of the work. Maybe they're credited somewhere in the magazine. And because of that, they were like, Vogue, don't do it again, but whatever, we can move past this, right? There's also the level of like, ADOR as a company still needs to soothe investors. Like, Korea as a country is going through it right now. The government is all over the place. The entertainment industry, one of their biggest industries, is all over the place. The economy has been bad. Like, before December, the economy has been bad. And now there's this recent tragedy as well. I think all businesses in Korea are very aware of that. They run very much so on foreign investment, and investor confidence is at its lowest since Korea has become a developed country. So I think there could be a level of ADOR trying to pick their battles, because there's a bigger picture for them to pay attention to as well. However, on the flip side, I do also think that ADOR needs to be a little bit more aggressive, especially with the Omega Watch situation. This is a prime example of somebody going against what they've said and working with their artists without involving them. And ADOR did say in their early statements that if you work with our artists, we will sue you. We will take legal action. So if that comes up, like if that appears to be an empty threat, it actually opens up more opportunity that more big brands, especially, like I said, brands who can afford to pay any potential legal fees later down the line, will work with NewJeans now, because they see it as like an investment cost essentially, or they see ADOR as all bark and no bite. So yeah, I would like to see ADOR sue Omega Watch, sorry. And I would like to see also what comes out of the employee who was helping NewJeans, because I think that needs to be the first thing, honestly. I think they need to do that first, because if they know what deals that employee was working on, that could also be their legal precedent of like, okay, we investigated this employee, we were found that they were in breach of their contract or whatever, we were legally allowed to dismissed them, and therefore the work that they were doing was also illegally arranged. I think that could be an angle that they take as well. But yeah, there's a lot that ADOR needs to do, and I think they just need to list their priorities. And their number one priority is, of course, the lawsuit that involves but is not directly against NewJeans to prove the validity of the contract. Now, with the cancellation of year-end events and stages due to the ongoing mourning process following the tragic accident at the Muan airport, it is unlikely that we're going to hear much buzz from NewJeans in the next couple of weeks, or at least in the next week. But we still do have their little Christmas radio appearance that we will talk about in an upcoming video, and honestly the cult-coded t-shirt that Minji was wearing, which throws me for a loop every time I see it. On top of that, there is also the first of Minhyejin's hearings in the B-Lift lawsuit against her. Remember, they're suing her for, I believe, obstruction of business and defamation of their artists, and that is happening. It's scheduled for January 10th. It might have been moved now, I don't know, but if that does happen, I'm sure Minhyejin will do her typical media play or try to use the NewJeans girls to stir up some sort of controversy to cover that up. So who knows, maybe in the next 2 weeks we're going to have some new content to look at. But anyway, remember to subscribe so you don't miss any updates, and let me know what you thought about all the things we discussed in today's videos, and what do you think ADOR's legal play is going to be in regards to Vogue and the Omega Watch debacle. And I also want to let you guys know that I will be mixing things up a little bit in my upcoming content. I will continue to do this commentary stuff that I can see you guys are really enjoying, but there's other content that I want to make too, and I'd appreciate it if you guys would give it a try and check it out while you're waiting for the next commentary videos. Anyway, this has been Han from the Haniverse. I hope 2024 treated you well, and if not, 2025 treats you better. Happy New Year, and thanks for stopping by. Annyeong!